Hello students, welcome to another session of Law Optional Simplified. Now in this discussion, let's understand about the historical development of international law. Now this is important to understand as you can see as a part of your syllabus, it is nature and definition of international law. Now to understand the nature and definition of international law, certain historical perspective is important to understand as it will give you more clarity about the entire perspective or about the nature and also how the definition of international law has changed over a period of years. Now if you look at these two questions asked by UPSC, in 2022, the question was keeping in view the growth of international law in the contemporary era, do you think the classical definition of international law has become redundant? So, it's important to understand the nature and the basis of classical definition and how this definition has changed over the period of years. Now, this question asked in 2021, it says that discuss the various efforts made towards codification of international law during the 20th century. So it is talking about the changes which has taken place over a period of years, particularly in the 20th century. So to understand the definition of international law and also the codification or various changes which has taken place, it's also important to understand certain historical backdrop and political developments which has taken place. Now let's look into this definition provided by Professor Oppenheim. He says that law of nations or international law is the name for the body of customary and conventional rules which are considered legally binding by civilized states. Now look into this term civilized states in their intercourse with each other. So overall what we understand is that this international law is a set of rules governing so-called civilized states according to this definition. So there is a set of rules, set of customary norms, which are generally agreed upon by civilized states having legal binding or having legal obligation. Now, these two are the new definitions, and these says or definitions in the newer era. And it says that international law is the body of legal rules which apply between sovereign states. Now, look into the term sovereign states and such other entities. So, here it talks about application of international law not only between sovereign states but also between other entities. So, this is the change which has taken place in the modern era. And these other entities includes international organization, corporations, and even individuals. So, the jurisdiction of international law, we can say, has expanded. Similarly, Fenwick highlights that international law may be defined in broad terms as the body of general principles and specific rules. So it's talking about general principles of law and certain specific rules which are to be applied by all the sovereign states or other entities which are binding upon members of international community. So it is also saying members of international community rather than merely civilized states. So this being one of the change from the past, as other entities are now also considered to be part of international law. Now the question is that who can be said to be a part of international law? First, those who can claim their rights or duties in the international arena, or those who have a corresponding legal obligations in the international arena. Now, having said this, it's important to understand the overall historical development of international law from these different perspectives and certain important events, as it will help us to have a more comprehensive picture or greater clarity when we study in particular or specifically about the nature of international law or about the definition of international law. So, we need to understand the overall growth of international law from the perspective of a certain timeline, mostly starting at 1648 from the Peace of Westphalia. Now, this Peace of Westphalia is very important as this Peace of Westphalia happened after 30 years of war in Europe. And the important aspect of this Peace of Westphalia is that from this treaty or from this peace emerged the theory of sovereignty of states. This is very important, or this development of, or this emergence of notion of sovereignty of states is important, because ultimately, as we have studied, that according to Professor Oppenheim, this is the international law is a set of customary rules and conventionals which are considered legally binding on civilized states. So the aspect of sovereignty is important, and it was during 1648 this notion of sovereignty emerged. Now, Peace of Westphalia has also impacted various legal scholars, such as Hugo Grotius, who is also considered as father of law, and also other scholars, including Thomas Hobbes. So, it's important to understand these overall development from a timeline perspective. Then we also need to understand the historical development of international law from the perspective of contribution of scholars such as Hugo Grotius, also known as father of international law, Alberico Gentili, Austin, Jean Boding, Thomas Aquinas, Zausch, or Bankershoek. Now, from 1648, from the Peace of Westphalia, we also see emergence of the concept of positive law, along with the separation of theology from reasoning. So, the aspect of divinity was separated from natural law, and natural law was said to be more on the notion of human intellect or human reasoning. So, all these developments have taken place post the Westphalia or Peace of Westphalia. Hence, it's important to understand the Peace of Westphalia. Further, Renaissance in Europe and also Industrial Revolution further impacted the overall development of international law, as we see increasing trade among various countries. Then we need to understand the growth of international law from the perspective of development of various institutions such as League of Nations, United Nations General Assembly, UNSC, WTO, or other institutions. So we also need to understand international law from the perspective of institutions or even treaties or conventions. And lastly, some important judicial pronouncements of ICJ or PCIJ. So, when we study international law, these are some of the aspects which we must understand, as these will help us or give us more clarity to understand the overall nature and definition of international law, which is also a part of our syllabus. Now, other than this, we also need to understand or have a clarity with respect to the development in certain timelines. So, the timeline here is from Peace of Westphalia, which was in 1648 till 1918, where we saw the emergence of First World War, the developments between First World War and Second World War, the developments between Second World War and end of Cold War, and it is here where we see a large number of institutions being developed. And from 1990 onwards till present circumstances or till present situation. So this is another way to understand the growth of international law. So, as I've stated, that contribution of different scholars are also important. And for the first time, Francisco Vitoria and Francisco Suarez highlighted the universal application of international law for the first time, as they stated that indigenous people or Indian people of Latin America or South America also should be considered as an independent state or should be considered as an independent nation within their own rights. Alberico Gentili and then Hugo Grotius both made significant contribution towards development of international law through their treaties, that is commentaries on war and also that of peace. So their development is very important. Now, talking about Hugo Grotius, who is also known as father of international law, his contribution should also be considered from the perspective of the developments which took place during the 30 years war period in Europe and also after the Peace of Westphalia. So, first of all, let us understand what happened prior to the Peace of Westphalia and how Peace of Westphalia in Europe led to further development of growth of international law. Now, during the 30-year war period prior to 1648, the states in Europe were fighting amongst each other. And this fight was mostly or largely between Protestants and Catholics. So, in this fight, on one hand, there was the Holy Church, and on other hand, the kings. So, basically, the fight was between monarchy and also the church. So, we see a separation of dichotomy between church and the kings. And this Peace of Westphalia, for the first time, ended this conflict and, in a way, promoted the doctrine of or promoted the notion of sovereignty of states. And this ended the conflict between church and also the kings. This, in a way, emerged or led to the emergence of doctrine of sovereignty. So it says that concept of state sovereignty emerged, and this ended the conflict between king and church. And this conflict also impacted the intellectual development which was taking place in that time. And even Hugo Grotius was impacted by the 30 Years' War because it had cost many lives. And Hugo Grotius wanted to end those wars, or he believed in an era of peace. Further, the Peace of Westphalia led to expansion of religious freedom because of the end of conflict between Protestants and Catholics. It then says importance was also given to peace through negotiations or diplomacy among sovereign states. So it was for the first time that number of states, for example, 96 states in European or in Europe, they came together and they negotiated on the terms of the Peace of Westphalia. But no nation was supreme enough, or we can say that no nation dictated the terms of peace to another nation. So this aspect became another important cornerstone of Peace of Westphalia because it forwarded the notion of diplomacy among equal states. And it also, or the peace treaty also led to decentralization of power in Europe. So, Peace of Westphalia overall is a significant development or significant milestone to understand the historical development of international law. And based on this, the Peace of Westphalia also impacted the writings of Hugo Grotius. So it says was strongly influenced by 30-year war in Europe and sought to minimize bloodshed. He constructed a general theory of law that would restrain and regulate war between various independent powers, including states. So, as you can see, the Peace of Westphalia not only provided religious freedom, but the emergence of doctrine of sovereignty or the concept of sovereignty further led to the development of international law. Now, Hugo Grotius also favored open seas for trade. So he stated that he opposed the idea of closed seas and emphasized the importance of freedom of high seas for international trade. So Hugo Grotius is considered as father of international law because for the first time he advocated the idea of a common set of rules between these different sovereign states. Now, the contribution of Francisco Vitoria and Francisco Suarez is very important in the development of international law, as they can be said to be the first scholars who advocated the universal application of international law. So they said that Indian people in South America should be considered as nations within their own legitimate interest and stated that war against such states to be justified on just causes. So again, we see these developments over a period of years. Then we have Alberico Gentili. Now he is considered as a second school of thought in international law. His contribution, namely De Jure Belli, or series of 3 books on law of war and treaties, initiated a transformation of law of nature. That is, it separated the theological concept or the religious concept from the concept of secular philosophy founded on reason. Now, coming back to Hugo Grotius, his book De Jure Belli et Pacis, and this book was written prior to the Peace of Westphalia, when the 30-year war period was going on in Europe. And here he gave a systematic overview of international law of war and peace. And he was the first to say that relations of states should be governed by commonly agreed rules and laws derived from natural law and manifested in the just war tradition. So his book gave an overall commentary on treaties of war and also that of peace. Further, he secularized international law by separating from the theology and divine law. And he also advocated importance of freedom of high seas. So, Hugo Grotius also put forward the theory of Alberico Gentili. Now, another important development which we see post Peace of Westphalia is that from natural law, the aspect of theology was separated, and the emergence of sovereign states, or the so-called doctrine of sovereignty, further led to the development of positive law. And after or during that era of Peace of Westphalia, we also see the development of theory of sovereignty by Thomas Hobbes and also by Jean Bodin. So these are some of the relevant developments which has taken place post Peace of Westphalia. And all these developments will help us to understand the nature and basis of international law. Now, positive law is basically what states actually do, and natural law is an ideal concept where it says that what states should ought to do or what states should do. Now, positive law further led to the development of treaties and customs among states, mostly with respect to, say, treaties on war or treaties on trade, etc. Now, as I've highlighted about the growth of positive law, then these 3 important scholars it's important to understand about their development. As Thomas Hobbes highlighted about supremacy of sovereign power irrespective of just or unjust laws, whereas John Austin, we all know that he highlighted that law is the command of the sovereign, and his positive law comprises of 3 important elements, namely sovereign, command, and sanctions. And Jean Bodin in his book highlighted or emphasized the necessity for a sovereign power within the state that would make laws. So we see the development of positive law as well post Peace of Westphalia, along with the emergence of sovereign states, which was a key highlight of Peace of Westphalia. So moving from 17th and 18th century towards 19th century, and here we see intellectual and scientific growth further expanded international law. And we see Congress of Vienna set up in 1815, which was an international rules for navigation of international rivers, categorization of diplomatic agents, etc. Then we have the Paris Declaration of 1856, where 55 nations agreed on the diplomatic policy of maritime law and laid down rules relating to naval warfare. Then we have Geneva Convention of 1864, formulated rules and regulations for protection of victims of armed conflict and people involved in providing care to them. And lastly, we have the Hague Conventions. Now, there are 4 Hague Conventions. And this basically established the Permanent Court of Arbitration, which provided a peaceful settlement of international disputes and also dealt with treatment of prisoners and control of warfare. So these were some of the development in the 19th century. So if a question is asked by UPSC, the development of international law in the 19th century, I hope you can highlight these important points. Now moving to the 20th century, or developments in international law in 20th century. The 20th century was one period where the overall growth of international law moved out of Europe, as there were two world wars and two important set of institutions which were constituted. One was League of Nations and the second, of course, is the United Nations. So in 1917 we see February and October revolutions in Russia. This led to the creation of Soviet Union, increase in influence of United States of America. So we see the increase or influence of international law through USA also, birth of Soviet Union, and European states no longer key players as there are other players as well. So we actually see the expansion of international law beyond Europe, and we see new players entering into the field of international law, mainly the United States of America. 1920 saw establishment of League of Nations, but as we all know that it was not a success. Yet it was one of the first efforts to establish an institution on an international scale. Fundamental in development of international law, as common consensus was to prevent war and achieve peace, but it failed. Then we have Permanent Court of International Justice to settle international disputes. Fundamental change in thinking took place as settlement of disputes through negotiations and diplomatic means other than use of force through multilateral approach. So the approach was not bilateral but rather multilateral, that which means many nations were involved. Then we have 1939 to 1945. Obviously we had the Second World War. This also meant that League of Nations could not succeed as the countries further resorted to war. And after the Second World War, we have the establishment of United Nations and its important principal organs. So 1945 saw the establishment of UN and its various organs such as United Nations General Assembly, United Nations Security Council, Trusteeship Council, Economic and Social Council, Trusteeship Council, and ICJ. Now, ICJ, that is International Court of Justice, became UN's principal judicial organ. We also saw the establishment of World Bank. So, on one hand, we have an institution to ensure peace in the world, and on the other hand, other areas of other areas of development is also taking place. For example, the international trade law. Now, in 1947, as a part of political development, start of strong geopolitical tension and political rivalry between US and USSR, which lasted till the end of Cold War in 1990. Decolonization begins in Asian and African countries. Slowly, number of free sovereign states increased, and we also saw establishment of General Agreement of Tariffs and Trade, that is GATT. Now, in 1961, other than the establishment of these institutions, we also saw emergence of important conventions and treaties. And in 1961, we had Vienna Convention on Diplomatic Relations, 1961 Vienna Convention on Law of the Treaties, also referred as VCLT, 1995 WTO, 1998 International Criminal Court through the Rome Statute, and many other institutions as well. So these are some of the developments which has taken place throughout history with respect to international law. Now, when we talk about the present era, then we have various other kinds of international, or we can say problems in the field of international law, such as cyber terrorism, international environment law, issues relating to international terrorism, biological warfare, or nuclear warfare. There are various conventions to deal with all of these, right? So overall, this is a complete understanding of the historical development of international law, as this will help you to understand the key components of the nature and definition of international law, as it highlights that the present era also saw emergence of new actors in the field of international law, such as states, international organizations, corporations, individuals, and we also see a change in balance of power from bipolarity to multipolar world order. And as we also witness emergence of regional organization such as BRICS, quad, or say ASEAN, BIMSTEC, etc. So all these can be associated also with the overall development of international law, starting from the Peace of Westphalia, when we consider the modern era or the development of international law in a modern sense. So I hope you have understood this entire concept of development of international law, and it will give you more clarity when you study about nature and definition of international law. Thank you very much.